Well, good afternoon, everybody. Congratulations for being here, and best of luck. And we're glad to have you. My name is Ali Khan. I am an attorney in Chicago, and I'm actually an alum of the program from the state of Illinois.
Sorry, my name is Ben Glickman. I'm also actually an alumnus of the program. I participated from California back in 1995. In my day job, I work for the California Attorney General's office, and I'm also a member of the Center for Civic Education's Board of Directors. Congratulations.
Good afternoon. I'm Dan Taubman. I am not an alumnus of the program, but I've worked with We the People for many years. I am a senior judge with the Colorado Court of Appeals in Denver, Colorado. Welcome to the competition.
Would you please introduce yourselves?
Good afternoon. My name is Kara Daughtery.
Hello, my name is Lexi Crawford.
Hi, I'm Kayla Bowling.
I'm Vance Moore, and we represent Highlands High School in the Commonwealth, Kentucky, and guided by our teacher, Ms. Boyman-Hennies.
Well, it's good to have you here, and again, congratulations. So today we'll be doing question 1. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin.
Since the establishment of judicial review in Marbury v. Madison in 1803, it has vastly impacted federalism. In this decision, John Marshall established that judges must declare the meaning of the Constitution and must defend this document in order to preserve the nation's fundamental law and will of the people. Judicial review has shaped the relationship between state and federal governments by establishing that the federal government has superior oversight.
The founders of our country aimed to create an equal government between state and federal governments, discussed in Federalist Paper 45. Madison argues that the balance of power between state and national governments will support the greatest happiness for the people. But the Anti-Federalist Party feared a strong central government, seen in Brutus I. Ultimately, the Constitution was ratified. This new relationship between state and federal governments can be seen in Article 1, Section 8, which established the powers of Congress, Article 6, the Supremacy Clause, which made the Constitution the supreme law of the land, and in the 10th Amendment, which reserves powers not delegated to the federal government to the state governments.
Prior to the Civil War, substantial power was granted to the federal government through judicial decisions such as McCulloch versus Maryland, in which courts expanded the power of Congress to include implied powers. However, overall, federalism at this time was more beneficial to the states. In Dred Scott versus Stanford, the Supreme Court ruled that the national government lacked the authority to ban slavery in the territories, and therefore gave states leeway to make laws related to slavery, like the Fugitive Slave Law.
After the Civil War, the federal government developed more power with the aid of judicial review. The Southern states' secession hastened in the need for the constitutional decision on slavery. With this, the power shifted to a federal level in an attempt to maintain the Union. The enforcement of the Reconstruction Amendments allowed for multiple declarations of state laws null and void.
Judicial review is seen by some, such as legal scholar Alexander Bickel, as a counter-majoritarian practice because the process of reflecting the will of a popular majority in the legislature is deflected by various inequalities of representation, which perhaps tend most often in favor of inertia. In Cooper v. Aaron, the Supreme Court ruled that the Arkansas District Court couldn't halt desegregation, ultimately establishing judicial review as a counter-majoritarian practice.
While judicial review is a counter-majoritarian practice in some ways, it is essential to protecting the rights of the minority. Footnote 4 of the Carolyn Products versus the United States established that the Supreme Court should apply a form of heightened scrutiny in cases where a conflict invalidates the Bill of Rights. Recently, the court has served as a necessary counter-majoritarian practice in its decision in Oberfeld v. Hodges, in which the court declared that state bans on same-sex marriage violated the 14th Amendment's Equal Protection and Due Process Clause.
While there are few limitations on judicial review, they are significant. For one, cases have to be brought before the Supreme Court. Additionally, the abstention doctrine affects all levels of the judiciary, further strengthening the bond between judicial review and federalism. This doctrine states, A United States court may apply to refuse to hear a case if hearing the case would potentially intrude upon the powers of another court. Likewise, Gitlow v. New York ruled that the Bill of Rights is now applied to the states, undoing the precedent set in Barron versus Baltimore, thus allowing the abstention doctrine to be more effective in protecting our natural rights.
Furthermore, Hamilton stated in Paragraph 78 that the judiciary has no influence over either the sword or the purse, meaning the judiciary has no power to pass legislation, nor do they have military support to enforce their rulings. They must rely on other branches. In the case of Worcester v. Georgia, the Supreme Court declared that states do not have the right to impose regulations on indigenous peoples' land. President Andrew Jackson refused to enforce this ruling because of the aforementioned limitations and various others. Further limitations should not be placed on the practice of judicial review. Thank you, and we are ready for your questions.
Thank you guys, great job. Let me ask you guys a question. Do you believe there should be term limits put on Supreme Court justices?
In my opinion, I do not believe so, because of with term limits being applied, there would have to be some kind of change within multiple presidencies. Within each presidency, most likely multiple Supreme Courts would have to be added to this court, and with this, it would cause more. It would cause more inefficiency in having to place a new Supreme Court justice.
I agree with my colleague. There should not be term limits placed on the Supreme Court. Supreme Court justices hold their positions under good behavior, and if they knew that their term limit was coming to a close, then they might not be under good behavior. So the term limit should not be put in place.
What if you had a term limit that was long, but not lifetime, let's say 20 years, 15 years, enough to not be beholden to the whims of the day, but not having someone there for 40 years?
I believe that
Go ahead.
I believe that could be plausible to, if you were to have like a term limit for 40 years, that would be allow for new introductions of progressive ideas and to truly represent the means of the people, instead of having a Supreme Court on the court for 80 years from a president who is elected in the 80s when we're in the 2020.
I agree with my colleague. I think term limits could be beneficial because they allow for new opinions and ideas to be brought to the Supreme Court, and that these term limits could just allow for new generations of idea and to see new perspectives.
Thank you.
Thanks. I wanted to circle back to Federalist 78 that you mentioned at the end of your prepared remarks. So it's clear that the lack of enforcement limits the Supreme Court in that it can't enforce its decisions. Do you think that the lack of an enforcement power influences those decisions? In other words, do you think it changes how the court might decide a case, knowing that they won't be able to enforce it?
Justice Marshall set the precedent that judges on the Supreme Court must hold the true meaning of the Constitution. So I don't believe whether or not they had those enforcements or not, they would change their rulings, because their job is to truly uphold the Constitution and only the Constitution for the will of the people.
You mentioned in your opening statement the Obergefell case about same-sex marriage. And do you think the Supreme Court should decide cases like that that are controversial and that have a political tone to them? Or do you think that those issues should be better left to Congress or state legislatures?
The Supreme Court's purpose is to decide what the Constitution states. And I think when it comes to cases that are more controversial and aren't explicitly mentioned in the Constitution, it shouldn't exactly be left to them. But in the legislature, it may pose some problems as well.
I agree with my colleague that it should not be totally left up to the federal level, but that the state, because of the controversy, that the controversy can be changed between each state. And that's why I believe that each state should have a say in how it's proposed.
Cases involving identities of the people, whether it be race, sex, gender, etc., should be protected across all levels of government. While the federal level should not have as much control, but when those cases of identity are under attack and need to be defined under constitutional values, the Supreme Court should take charge.
I agree. I think that these rights should not be left up to debate between political parties. I think that the Supreme Court needs to uphold their decisions in protecting the rights of the people. And these cases need to be dealt with by the Supreme Court so that they can uphold that promise.
One way the Supreme Court did this was in Loving v. Virginia in the late 1900s, where they instantiated the right of interracial marriages.
How, would you or would you not support an expansion of the Supreme Court?
President Biden is currently working on expanding the court. Personally, I think that the 9 justices has been a thing for so long, and it has proved fairly effective that adding more justices may cause more trouble.
I agree with my colleague as well that we should keep our current standings, because with more voices in there, it could lead to inefficiency.
I agree with my colleagues as well, but if more additions to the court were to be added, it should be kept at an odd number to prevent from long discussions and an unbreakable tie.
Thanks. In your prepared remarks, you mentioned how after the Civil War, the balance shifted more towards the federal government. Could you describe what is the doctrine of selective incorporation and how did that alter the Federalist balance?
As mentioned in our opening statement, we talked about Gitlow v. New York and how it talked about federalizing the Bill of Rights. Federalizing the Bill of Rights now applied the Bill of Rights to state courts and cases instead of just federal courts. So our rights could be more protected for the people. The doctrine of incorporation was basically established in that case and allowed for those rights to be more protected.
An extension of those protection of rights can be seen in recent times in the case brought to the Supreme Court in 2005 that declared that Missouri's law allowing for minors to face the death penalty was unconstitutional and a full form of cruel and unusual punishment according to the 8th Amendment and 14th Amendment.
Are there any aspects of the Constitution or Bill of Rights that have not been incorporated, and do you think they should be?
Sorry, could you repeat that question?
Sure. Are there any parts of the Bill of Rights or Constitution that the Supreme Court has not yet incorporated against the states? And do you think that those should or shouldn't be applied against the states?
I think the Supreme Court has done a good job with the cases that have been presented to them so far, honoring that doctrine of incorporation. As we mentioned in our opening statement, we talked about the abstention doctrine, which means that each court doesn't have the right to step over each other's toes, but the Supreme Court can review the federal court's decision. And with Gitlow v. New York, I think though Gitlow v. New York and the abstention doctrine have worked really well.
Are there other doctrines besides abstention that allow the Supreme Court or limit the Supreme Court in terms of the cases that it hears?
There is footnote 4.
You may finish your sentence.
There's footnote 4, which establishes 3 levels of scrutiny. There's strict scrutiny, intermediate scrutiny, and rational scrutiny, in which they protect the different levels of which levels of identity and person and their rights.
Okay. Oh, thank you.
Congratulations, great job. And now the judges have some feedback.
Well, thank you again, guys. And again, congratulations for being here. I know it's not easy, so wonderful job. In terms of feedback, I think you guys did a really good job, especially in terms of everyone participating. I really appreciated that, of everyone jumping into a question, and kind of everyone showing everyone's engaged. That was a big thing to me. So I think you guys did a really good job on that. Other than that, man, I enjoyed your prepared remarks, and yeah, I think you were a really good job. And so that's kind of all the feedback I have right now. I don't know, Ben, maybe you want to add to that.
Sure, I would echo that. I thought you guys did a very nice job. I thought in the prepared portion, you provided a very good history, talking, Federalist 45, Brutus 1, going through the provisions in the Constitution. And I liked your kind of thesis that initially judicial review benefited the states. And it wasn't really until after the Civil War that balance shifted. And I might have liked to hear a bit more about that. I think you probably could have said more about selective incorporation and how the court has used that since Gitlow, in the 100 years since. But I thought that was a good way to frame it. And you had, good support throughout the prepared remarks. On the Q&A, I thought you had pretty good support. You said some things I hadn't really heard or considered before, like for example, on the term limits question. I hadn't really thought about the potential that a justice could go crazy at the end of their term and just start doing whatever. I thought that was an interesting point, and probably not wrong. It's certainly plausible. And then again, on my question about the lack of enforcement, what I was trying to get there is I think my view is that the court is very aware that it doesn't have the enforcement power. And so I think that tempers its eagerness to get too far out in front of public opinion. And so I think, it will not take a case if it doesn't think the public is ready for a decision, maybe. And so, like, for example, in Brown v. Board, that, of course, reversed Plessy v. Ferguson, but it also, Justice Warren was really adamant about having a unanimous court for that case because he knew it was pushing public opinion. And he thought that the only way it might be respected is if all 9 justices were on board. And so I do think there are elements of the court certainly aware of public opinion and the fact that it needs the public to buy into its decisions. So I think that's a fruitful area for you guys to consider. But very nice job overall.
I agree with my colleagues. I liked the details you had in your opening statement, including references to Marbury v. Madison and McCulloch v. Maryland and Federalist 78, which you didn't mention until towards the end of your opening statement, but you mentioned it. I like the fact that you referred to footnote 4 in the Caroline Products case, but that perhaps defines how the Supreme Court addresses certain issues, but not necessarily limits the issues that the Supreme Court would consider. But I think that's good that you mentioned that. I think you did a nice job answering the questions. But I thought some of the answers with regard to my question about Obergefell weren't clear in terms of saying, well, we shouldn't leave this totally to the Supreme Court. And some of you said, well, it should be decided by the Supreme Court. If it's not left totally to the Supreme Court, how do you decide, or how does the Supreme Court decide what to hear and what not to hear? There is a political question doctrine, which the Supreme Court used to use, that hardly ever uses now, to say, we're not going to decide certain issues. And I asked at the end if there was besides abstention, if there are other limits on the cases the Supreme Court hears. Then there are a number of doctrines, including the political question doctrine, mootness, which was just used by the Supreme Court recently in deciding to hear a case involving President Trump and the emoluments clause. They said it was moot because he's no longer president. So that's something that you might have mentioned. When Ben asked you about the exceptions to the doctrine of selective incorporation, there are, I think, 3 exceptions, including the Third Amendment and jury trials in civil cases, and I forget the third one, but you might have mentioned that. But I think that your knowledge of the selective incorporation doctrine was good, and your overall knowledge shows to me that you have a really good understanding of the question and all the aspects of this issue of judicial review, which is, I can say as a judge, I think it's very important. So congratulations on your presentation.